Dr.
Yeah. Hi.
So, very importantly, we now have our instructor, Ashok. So, Advocate Ashok is a legal professional and he comes with extensive practice, expertise in areas of dispute resolution, including arbitration, taxation, company law, real estate. He is one of the partners of Allied Law Practices, and it's a full practice law firm. And they have their offices in Bangalore, Delhi, and I think very recently they have also had a firm in Abu Dhabi. So it's an international firm today. And as far as Ashok's IP law practice is concerned, it spans from domestic and cross-border IP strategy, trademark, copyright, trade secret litigation. He has advised a number of startups, multinational corporations, and government entities across various sectors, including space, privacy, data security, defense, healthcare, manufacturing, technology, etc., etc. In addition to the legal representation, he frequently delivers lectures on intellectual property management, enforcement, and helps businesses navigate complex legal and regulatory landscapes. He's had a number of accolades. The list it just goes on, but just a few that I want to mention here. That Ashok is a global fellow with the European Space Policy Institute. He is deeply engaged in space law and policy, contributing to discussions on regulatory frameworks, private sector participations, international cooperations, etc. So he also advises the governments and military forces regularly on space governance, treaty compliance regarding space ventures, etc. And he's an international speaker as well. This is the shortest that I could introduce about Ashok. Otherwise, you should visit him on his LinkedIn page, and he has his whole profile. Fantastic, Ashok, that you are here with us today. And the subject being copyright law. And I'm sure there's going to be a great takeaway at the end of this session today. Thank you, and over to you, Ashok.
Thank you so much, ma'am. And I realize I owe you an apology because I was supposed to send you a shorter profile, which I completely
No, that's fine. Absolutely.
Okay. So, good evening, everyone. Thank you so much for taking the time on a Saturday evening to discuss copyright. I'm hoping that in the next 1.5 hours, we kind of learn to see not copyright in the sense of a law or in the sense of sections and rules and case laws. But I want us to really start asking ourselves what is the value and the utility of imagination in the 21st century. I think if I'm successful in perhaps igniting that question in the minds of my audience, I feel that would be the best service I can do for my subject. Right. So let me first. So before I move to the crux of the topic today, let me first ask this question. What is the role of imagination in the 21st century? Because the moment we dwell into the topic of intellectual property or copyright, we are essentially dealing with a very key facet of what distinguishes humans from other species out there, which is our ability to conjure up imagined ideas. That's how we have accelerated our genetic learning by leaps and bounds. So what is the role of imagination? If I were to ask, since we have a small audience, I think that's the benefit. Could each one of you quickly tell me what is the role and importance of imagination in the 21st century? I'll start with a familiar face. Deepak, would you like to take a shot at the answer?
I think expression versus idea, this type of things should be there in the originality.
Okay.
This one of the things should be there.
Sure, that's the topic of the law itself. Let's go outside of that. We are trying to discuss a topic that is almost always condemned in Indian circles, which is imagination, right? Which is often associated with artists, with writers, with sculptors and painters, and so on and so forth. What is the role of imagination in today's world? That's what I'm trying to understand. So forget about the law for a second. Right, I just want to think of yourself as a layperson. I'm sure we've all been, reprimanded for daydreaming or thinking about some drawing in the middle of a math class. So I want us to really just ask that question to ourselves: what is the role of imagination?
It will enables original expressions.
Original expression. So Yes, you could say that. What is the importance of original imagination? Let me ask that.
Sir, may I, if you would permit me?
Sure, sure. Please, please, please.
Sir, imagination, role of imagination. Sir, it is just like a dream. That I am today. I would like to give a simple example. Today, I am attending a IPR session in front. You are taking a session.
Okay.
I will be imagination. My imagination is tomorrow. I'll be a person who will be giving a. If don't take me wrong, I'll be a person who will be sitting in front of the audience as you are sitting. This is the imagination. And there are two types of imagination. I would like to even clarify that daydreaming and working hard. Daydreaming. Daydreaming means okay. I'll be the tomorrow. I'll be the what you say high court judge. Tomorrow I'll be a barrister. Without any hard work. Without any hard work. So the daydreaming is also good, but some hard work is also required. Okay, I want to be instructor in any, for example, in EBC. Tomorrow, I
Sorry. I'm just going to briefly interject my sincere apologies for that. I think
no, no.
the question is slightly different, right? So let me also rephrase it. Perhaps I was not clear. What is the importance of imagination in the 21st century?
Sir, without imagination, you can't achieve anything.
Can't achieve anything. Very good. Okay, that's one good answer. Kashish, would you like to weigh in? What do you think is the role and importance of imagination in the 21st century? Or, for example, should we have better storytellers in India? So the question is, what is the role and importance of imagination in the 21st century? Right. As a related question, I was asking, do you think it is important for India to, for example, have better storytellers?
Yes, it is very important for today's world because it gives us new ideas, new problems, and also there is no creativity without imaginations. It gives our mind strong and help us to see the world in different ways.
So let me rephrase this question and go a little deeper, right? I think we're still scratching the surface of the topic. Let's assume that we are rebuilding India from scratch. Okay. Everything has to be constructed afresh. We don't have anything around us. Now, there are four of you in this room, and we have to figure out what can you do in terms of building the country from scratch. Okay. So that's the problem statement. Everybody clear with the context?
Yes, sir.
Okay. Now, here comes one person who comes and tells the four of you that look, we have to build a country from scratch. There are only two professions you can choose. Okay, not more than two. Okay, no other topic other than these two subjects are available for you to work in. So, the first field available to you to take up as a profession is that of an engineer. Okay, somebody who can, for example, construct a building, put together a road. That's option number one. Option number two is you can be an artist who conjures up big, paintings of what the country should look like. Now, if you have to choose between the two, considering that the country has to be constructed afresh, what do you think is a more important profession for the construction of the country?
Engineering.
Engineering.
Okay, Deepak. So I'm just going to again bring up the share screen option, and I want you guys to see something and see if you can recognize what it is. Okay. Do you know what this is?
Yeah, fighter jet.
It's a fighter jet. Do you know what fighter jet it is?
Stealth.
Stealth. Very good. But do you know which country, what model?
Sir, some foreign fighter jet,
Okay.
I suppose.
Good. Let me just stop here. This is what is the new fighter jet of the Chinese Air Force. It's called the White Emperor, right? It's a sixth generation fighter jet. If you did, what stood out? The shape was very different, right? If you've seen any of the conventional fighter jets and you saw this, something about this was a little funky and off. Would I be right in saying that? Something new, something creative, not the usual fighter jet. Kashish, would I be right in saying that?
No, it's a little different than the F-35, which is fifth generation, and the Su-57, fifth generation from Russian.
Correct. So this is the sixth generation. So China has gone one step further. But the question is not that. Question is, did the design seems a little different? What did it seem creative and new?
Sir, some updates have been done. The shape.
Right. So it is an upgraded aircraft. It is supposed to be the most superior fighter jet of its time. But what stood out the most was the design of it. there seemed to have been something very new and novel about it, right? And that novelty or newness, for the lack of a better word, translates to national power. China is now being regarded as somebody who's giving the Americans a tough run for their money, because they have perfected something that even the Americans are now struggling with, which is imagination. They're able to conjure up new ideas in a speed and scale that America is not able to do it. And if any of you followed the aftermath of Operation Sindoor, one of the critiques that the Indian government has been encountering is the fact that we lost the information war because we did not have adequate storytelling in our narratives around the operation itself. And the one with a better story earned better international goodwill. Now, why am I giving you these examples? It is to point out one simple thing. Until now, we have imagined imagination as a extracurricular activity or a distraction, right? You imagine when you're not working. That's essentially how we have looked at painting, craft, sculptures, so on and so forth. But today, one of the striking features of the defense industry in China is that they realized that the American advantage in space and defense technology arose on account of their love for science fiction. So they read a lot of Arthur C. Clarke and a whole bunch of these other authors who were able to throw some really crazy ideas into their literature and fiction, which the scientists said, hey, this sounds interesting, let me go back. So one of the famous examples was the geostationary satellite of Arthur C. Clarke, which idea came out in one of Arthur C. Clarke's science fiction books. And turns out that the idea was so viable that scientists went to the drawing board and realized that they can actually build and launch a satellite that can act as a geostationary satellite. And that gave America the biggest advantage when it comes to satellite communication for the longest of time. So today, when the Chinese automobiles industry is able to come up with a car that can move sideways or go in water as well as come up on land, the engineers followed the ones with the imagination, not the other way around. So what I want us to really think about before we go into IP is that imagination is infrastructure, right? And today, our country's national power depends on its technological prowess. The technological prowess depends upon how we are able to instigate, nurture, and protect imagination and its cousin innovation. Okay. So when you guys are doing this course, I want you to really have that in mind. Because protection of ideas in India is not a matter of magnanimity or nobility. The need to protect ideas is now synonymous with the need to ensure that we're able to survive a geopolitical climate that is being increasingly contested and increasingly multipolar. So it is a steep national responsibility to ensure that we get things like copyright and design right. Right. So that is the idea with which I want to start off this session, because now more than ever, the storytellers, the painters, the sculptors, the people who can really come up with the wildest of ideas far ahead of its times, they are more critical to us now than they were ever before, right? So things like free speech, things like copyright, I want us to really start looking at it a lot more seriously than we're accustomed to. It is a matter of survival. Any questions so far?
Yeah.
Yes, Deepak, you had a question?
No, sir. Please carry on.
Okay, all right, sounds good. So if any of you really have any time on your hands, I would invite all of you to read this small little book by Oscar Wilde called if I remember the title correctly, it's called The Decay in the Art of Lying, where he laments about how human society during his time was losing the crucial art of lying, not in the sense of deceit, but in the ability to conjure up ideas and ideate things that don't exist with reality or don't align with reality. And one of the very interesting points that he makes is that art does not imitate life, but life imitates art. And I think nothing else signifies that better than technology, because oftentimes ideas for technology, especially space, movies like Star Wars and series like Star Trek. So I want us to bear this in mind when we start wondering why we should actually really protect ideas of authors, of books, of movies, because the next big breakthrough could come from one of them. Okay. So that said,
Ashok, could you please share that link, the name of the book along with the author on
yes,
the chat box?
I'll do that.
Anytime, yeah.
Sure. In fact, I think I'd also penned a small blog post on imagining the idea of imagination as infrastructure, where I've referenced some of these examples. So I'll also share that on the group.
Please do.
But I think as IP lawyers, we need to go much beyond just being able to read section 55 or 63 of the Copyright Act. We need to fall in love with things like literature, art, and everything else around it. We need to be the advocates for that community in amongst our circles. So when you hear a parent go to the child and say, don't waste your time trying to be a painter or be a writer, but instead why don't you become a doctor, engineer, or lawyer? If we can actually step up and say, hey, don't discard that as something unimportant, that's also crucial. I think that's a true IP lawyer. And I think unless we get there, I would still think that for us, IP is still a matter of livelihood and not a matter of a profession or a calling, right? Okay, let me now quickly jump to the topic. Especially given that we are also on the clock and I don't want to take too much of your Saturday evening, right? Now, the Copyright Act, of course, looks at defining several categories of things that can have copyright in them, right? There's sound recording, there's cinematograph film, there's literary work, artistic work, dramatic work, so on and so forth, all right? But let us quickly get down to what or how copyright works in reality. Now, how many of you have watched Harry Potter series? Okay, Game of Thrones, Harry Potter, Marvel Cinematic Universe, Spider-Man, Avengers, right? Some of you must have watched it. I would like you guys to probably answer this because I want this to be a conversation.
Marvel's few I have seen.
Okay.
Not every.
Any book that is turned into a cinema that you have probably had the benefit of watching? Kashish and Saideep.
They're posted on the chat.
Oh, okay. Okay, I see Harry Potter is a popular choice. Okay, that's great. Okay, so now when you look at something like that, which is an adaptation of a book into a cinema, you can see that it contains a variety of work that is copyrighted, right? On one hand, you have a literary work, which is the story of the book. And please correct me if so there is the literary work, which is the novel itself, correct? And then there is the script of the cinema, in which there is again an element of literary work or a dramatic work. If there are any songs which you frequently find in, say, Bollywood or Indian cinema, then within the lyrics, there is also another element of literary work. The musical work essentially involves
Saideep, please mute yourself. While the other participants are not speaking, please mute yourselves. Thank you.
So there's a musical work which could either be songs or the background music itself within the cinema. You will hear the violins playing throughout Harry Potter, and they'll have a distinctive original soundtrack, be it Marvel, be it Harry Potter, be it anything else. And in India, of course, we have a culture of song and dance built into the cinema itself. So the musical composition there has a distinct copyright. Then the soundtracks, of course, other than the background work, like we were discussing, so soundtracks comprising of the songs have distinct copyright. Within those songs, lyrics, the musical composition, all of that has copyright. Then the graphical notation of such works is also a copyrightable work, right? And let's assume, for example, you also have a book that's turned into cinema. Tomorrow it could become a graphic novel, in which case there is also an element of visual art that also has distinctive copyright in itself. So copyright is something that you'll have to look at in terms of a package, right? Which essentially encompasses the entire human sensory experience. So what you hear, what you see, what you sometimes touch in the form of sculptures, there is copyright in all of them. Now, one of you rightly pointed out that there is an ideas versus expression debate, which we will come to in a bit. But the moment we get into understanding what is the scope of copyright protection, you will have to necessarily go well beyond a simple book or simple written script on it. There's many more elements to it. Even within a song, for example, if there is a singer, the singer has performance rights, right? So you can just see that from the time the idea goes out of the author's head and into paper and becomes expressed in the minds of the artist and reaches the audience, there are various rights that comes in between. It includes, for example, the right to conceive an idea, the right to put an idea on paper, the way in which the idea is expressed, where copyright emerges. Once the copyright emerges, there could be the monopolies in terms of who has the right of broadcasting, who has the monopoly over the lyrics, who has the monopoly over the musical composition, who has the monopoly over the script, the dialogues, so on and so forth. There is, of course, the possibility of an aggregator. A producer of the movie can come and ensure that from all these stakeholders who have distinct copyright, he starts acquiring it under the guise of an agreement. And under the Copyright Act, a producer is also presumed to have certain rights, and because of the fact that he has invested money to be able to ensure that these expressions of ideas actually come out into the open. But all said and done, you will begin to realize that the way you look at copyright must be a lot more holistic. Like I said, you have to start looking at it as a holistic sensory experience. From what you see, from what you read, to what you perceive from with your various senses, perhaps copyright exists with all of it. Any questions so far? Okay. Now, when the copyright starts coming into existence, right? So there is a layer of vulnerability that comes about, because most ordinary individuals, when we go and watch, say, a Marvel movie, what we see is the package of the entire movie. We don't see the constituent elements because we assume that what comes to us is aggregated and presented to us in one single package. Now, whenever we talk about copyright protection, what we also need to understand is that copyright protection is one part dependent on the mechanism of the law. The other part is dependent on the effort made by people to enter into bilateral relationships to protect the copyright. So bear in mind one thing, that all IP laws, be it patents, be it copyright, be it trademarks, so on and so forth, what they do is to essentially either acknowledge and recognize a pre-existing right under common law, or they end up creating a new right in favor of individuals. So one of the earliest examples of intellectual property protection came from the United Kingdom, which is during the Industrial Revolution. Now, two things happened in the aftermath of the Industrial Revolution between the United Kingdom and Russia. So what happened with Russia was that the Tsar was in power, Nicholas. World War I takes place. By that time, the country is in steep economic crisis. The income inequality is so profound that the lower cadre of soldiers rebel against the officers and end up staging the biggest revolution in Russia, known as the Bolshevik Revolution. So Russia implodes. But the UK, by that time, becomes a global powerhouse, combination of two things. Access to unfettered raw materials thanks to excessive colonization and exploitation of the colonies. But the second thing was Industrial Revolution. Now, what enabled the Industrial Revolution and to get the UK ahead of Russia is the fact that UK came out with a system of recognizing innovation by granting statutory monopolies, saying that if you come up with a new idea, say the spinning wheel for textile industry or the steam engine, they said that we will give you a 20-year monopoly on it so that you can make a lot of money. But you in turn have to publicly disclose the idea to the state so that beyond 20 years, it becomes available for other people to innovate and improve upon. This simple gesture to be able to afford statutory recognition or a policy-based acknowledgement to innovation ultimately ensured that the UK went far ahead of Russia. The result being that UK is what it is today and Russia became what it is in the next few decades. Right? Now, once the right comes into existence, the inventors of the spinning wheel or the inventors of the steam engine, they could not look back to the state for any further assistance. State said that we recognize your right. But then what happens afterwards is dependent on how they monetize and how they go about being smart about their idea. And that's where the importance of agreements becomes absolutely critical. In today's day and age of collaboration and cooperation, what you saw in the form of the sixth generation fighter jet has a component of electronics. It has a component of design. It has a component of material sciences. It has a component of avionics. It has a component of electromagnetic engineering and a whole bunch of other things. Now, the only way the plane can come into existence if people come together and bring their respective ideas together. And what enables that to happen is a contract or an agreement. The first step towards copyright protection, therefore, is to ensure that there is a rock solid agreement or a contract that defines what is the scope of the innovation being agreed upon, who has the obligation to bring that innovation into existence, who has the obligation to bring that idea into existence or that expression of the idea into existence, what are the roles and responsibilities of each party to be able to achieve that expression of an idea. And once the expression of the ideas emerges, what are the kind of rights around it? right? Do you have absolute? Are you joint owners? Are you sole owner? Is one the sole owner and the other an exclusive licensee? All those things needs to be defined in the form of an agreement. Now, without this agreement, even the best of statutory protection can fail. So the need and the importance to be able to get the wordings of the contract right is absolutely critical. And if you read the origin of contract theory, one of the things that you see is that the theory of contract starts with the theory of exchange of ideas or the exchange of thoughts or the exchange of information. So IP or intellectual power of the human mind lies at the foundation of a contract, and therefore the contract is a product of the IP protection is a function of the contract. Right? So I can't stress on this enough. And one of the best examples in terms of being able to achieve the right kind of contracts around it is in the form of the licensing and assignment of copyright. How many of you have visited a restaurant or a pub which is playing music? And guys, if I'm not getting answers, I'm going to ask you guys to switch on your video, right? And I'm really hoping you won't push me to do that. Saideep, Kashish, Deepak, would you like to answer that question? Any of you been to a hotel or a pub that's playing music?
Yes, sir.
Okay. Now, was the music in its original form or was it a cover version?
Uh, Music was in original form sometimes, and sometimes they play some unplugged musics.
Okay, fantastic. Very good. Now, here's a question. Those establishments that were playing cover music, one of the best examples that I can think of, which does not necessarily involve live cover music, is instrumental versions of very popular songs that get played in a lot of restaurants. Why do you think those restaurants prefer to play a recorded or a live cover version than the original?
Because of copyright.
Very good. Because as opposed to you and I who are retail consumers of music, the industrial or the institutional consumers of the music are required to take a special license. Because the original distributor who sells the music to you and I, they perhaps don't have the right to sell to a commercial establishment which is going to replay that music to a larger audience. Now, a lot of times people probably not have the money to go and buy these kind of licenses. Usually these licenses are sold through a copyright society. It could be the phonographic, the PPF, or it could be the what's that other famous copyright society, that IPRS. It could be Novex. It could be any one of these copyright societies through which these commercial licenses are sold. Now, the right to distribute commercial licenses are essentially given to these copyright societies, who will in turn go about distributing the rights to broadcast this music to specific institutional customers like hotels and restaurants. Right? Now, whenever there is a failure to take these licenses, these guys will send their people to sit in the restaurant, order a couple of drinks, or maybe eat something while they're recording the music, which is then used to check whether or not the establishment has a right to play that music in a public setting. And if they don't have the right in their database, immediately what follows is an action for copyright infringement, either civil or criminal, right? Until and unless a license is purchased. Right? So why am I citing this example? Because what is the first thing that comes to our mind when we think of a contract? Saideep, would you like to tell me the first thing that pops in your mind when you think of a contract?
So consideration.
Consideration. Very good. That's a very legal answer. I like that. Thank you. What else?
Persons competent to contract with that can be considered first thing, then consideration. Because if it is done with a minor or any other person, it will be at a what you say null and void. First, you have to take into consideration those things.
Okay, so here's what I want you guys to do. You will have an option to give me the thumbs up sign because I'm going to take a quick opinion poll. Okay. Now, I'm going to say a couple of things about contracts. If you agree with me, show me the thumbs up sign. All right. Contract has a lot of words, English words. Kashish and Deepak, do you agree? Give me the thumbs up sign if you do.
Sorry, sir, I didn't understand the question.
The question is, when I say contracts, would I be right in saying it has a lot of words, English words?
Yes,
No,
sir.
Okay. Would I be right in saying that contracts are very lengthy?
No.
Okay. Saideep and Deepak?
No, sir.
No. Okay. How many of you read a contract for leisure reading to as entertainment?
Sir, some contracts, some maximum not all contracts are lengthy. Some contracts like employment agreements seem to be 1 or 2 pages. Otherwise, remaining major contracts like share subscription, they go bit lengthy. It depends upon the circumstances. What consideration is there? What
Okay.
clauses are to be added?
Fair enough. But I think all of us would agree that we wouldn't read a contract for leisure, right? It's not fun reading. We would much rather read a novel or a magazine or a newspaper instead. Let me ask the third question. How many of you think that a contract is a live human being who is able to speak to an audience and convey ideas? Saideep agrees. Kashish and Deepak, do you think contract is alive?
What the question? Contract is?
Is the contract alive or is it dead?
No, contract is in force. That means you want any contract, there is some validity.
No, that's not my question. That's an accurate answer, but that's not my question though. My question is, I am alive, you are alive, right? The question is a contract alive?
Yes, contract is alive.
Why do you say that?
Because if suppose contract has been signed by a person, two person, okay, any persons, anybody, contract between signed by two persons, and if the person who is concerned authorized representative has died after some time, the organization can change the representative, but contract will be alive till some times. I am talking for the infrastructure project. Suppose a contract has been signed for some extent for doing the works in 3 years time, and during the 3 years time, if somebody is passed away, one of the party, say employer, and other party that is an individual contractors, the contractor, these are organizations, so it will be valid till to the completion of the projects.
Okay.
That is also a contract.
Okay, so that's an accurate answer, but that's not my question though. My question is like, so my question is tomorrow, can a contract, for example, answer questions asked to the contract by a judge?
So could you please repeat the question?
Okay, my question is, tomorrow is a contract capable of answering a question asked by a judge? Is it alive?
Yes.
Okay. So the question seems rather stupid, right? What kind of a question is being asked is probably what's running in your mind right now. But let's go back to the oldest contract in India. What was the first contract that all Indians signed? It is the Constitution of India, correct? So it is essentially the manifestation of a social contract that we all agreed upon, saying that we, the people of India, come together. We are going to become the sovereign, socialist, secular republic. We're going to have fundamental rights. We're going to have directive principles of state policy. This is how we rule ourselves. This is how our courts are going to function. So essentially, we all signed an agreement to say that this is the country and this is how it will be run. Now, if you look at the evolution of that contract, when the contract was signed, none of the original signatories to the contract, which would be the several million or billion Indians that existed back in the day, never did they imagine that one day a bunch of people from the transgender community would come and say, decriminalize us and don't force us to be underground, right? But fact of the matter is that happened in Avdej Johar judgment, where the Supreme Court had to determine. Now, when the Supreme Court had to determine the answer to a question as to whether an entire community can be made criminals for their personal choices of life partners, one of the first things that the Supreme Court came back and did and said was something called as a doctrine of progressive realization of rights. And to put it in a nutshell, what the Supreme Court did was that it assumed that the contract is a child in its beginning. Now, the child has a lot of ideas, it has imagination, but it's still very young, it is still learning, it is prone to making mistakes. But as it grows up, its sense of right and wrong is supposed to become more and more refined. It's supposed to develop a very accurate sense of right and wrong. And what the Supreme Court said in the doctrine of progressive realization of rights is that as the contract becomes more and more mature, the social contract, the progress it makes is irreversible. If you have reached a certain path of enlightenment today, you can't go back, because that is anathema to how a live human being is. Right? With age, we are supposed to become more mature, not supposed to regress. So I want us to really start thinking of contracts as a live human being, because today, if, for example, Dr. Pratima and I enter into a contract where I agree to, for example, come and take a session, and all of you are witnessing it, right? That I agreed to come on Saturday evening and take a session on copyright law. And tomorrow, if I breach it and Dr. Pratima wants to take me to court to enforce the contract, a Deepak or a Kashish will take the witness stand and say, yes, I did see the fact that Dr. Pratima and Ashok had a contract and Ashok is in breach of the contract. That is exactly what a contract does. It is a witness or it is a scribe who is taking down what two parties have agreed upon. And because it is meant to be alive and because it is meant to answer questions at the hands of a judge, the way a Kashish or a Deepak or a Saideep would have to do in the event of a court case tomorrow, a contract has to be drafted keeping that kind of contingencies in mind. That is why a contract requires a lot of imagination, because you have to imagine contingencies and scenarios. What if there is a breach? What if Ashok turns up? What if Ashok does not turn up? What if Ashok turns up 10 minutes late, like it did today? I did turn up 10 minutes late. What should be the consequences? What if Ashok turns up and Kashish, Deepak and Saideep are not there? So you have to be able to imagine all these scenarios and then draft an agreement in such a way that you're essentially coding something to come into existence, right? That's the aspiration, that you essentially have on paper a Gen AI model of sorts that can quickly answer the questions that the judge would have if the contract between Dr. Pratima and I were to ever get enforced. Now, that would essentially mean that we take away Dr. Pratima and Ashok from the equation if tomorrow somebody asks the question, what is the contract? Because the idea is what? That I will tell that the contract is this to benefit my interests. Dr. Pratima may probably come back and put forward a case regarding the existence of a contract that is specific to the interest that she is trying to advance, which is on behalf of all the students. But how does a court know who is correct and who is not? The court knows who is correct and who is not by looking at that one instrument, which is a witness to my conversation with Dr. Pratima on this entire subject. And what the court is able to understand from the contract is essentially what prevails. This is the essence of English common law around interpretation of contracts. This is what Indian courts follow as well, that a contract must be able to answer all questions regarding the terms of the transaction without a third party or without the contracting parties having to come and supply that entire narrative, right? Now, in a typical copyright kind of a scenario, you are essentially looking at the subject of contract for two specific things. One is to address commissioned work. A producer approaches A.R. Rahman, for example, and says, I'm shooting a new movie, I'm producing a new movie, I would like you to be the music director. Now, because A.R. Rahman would otherwise not generate music for that film, there is a strong chance that the nature of the work he undertakes could be considered a work made for hire or a commissioned work. Now, to remove any confusion as to whether or not there is a transfer of copyright to the producer in a scenario of this nature, there is a contract that specifically talks about how many songs A.R. Rahman will give music for, right? And what is the kind of quality standards expected of it? Reasonable effort, commercially reasonable efforts, best effort, so on and so forth. There will be a process of review saying that I am, as a producer, I have a right to pay you money. You give me the draft of the deliverable, which is a musical composition. I will then review it and let you know if I like it or not. If not, you'll have to go back to the drawing board and give me something that I actually like. So these are all the things that gets addressed in the contract. And it must be addressed in the contract in a manner that tomorrow, if there is a disagreement between the producer and the music composer, the contract can independently tell the judge that, look, this is what he was supposed to do, the producer. This is what the music director was supposed to do. And this is where the people went wrong, either the music director or the producer. Maybe the producer did not pay the money on time. Maybe the music director borrowed a existing clip from an Italian movie and copied and reproduced the tune, which was against the terms of the contract, which said that it has to be an original work. So that the contract will have to supply to the judge, not the producer, not the musical director. So in that endeavor, your language cannot be either too complex in a manner that a judge will not be able to understand, nor can you afford to create a very lengthy contract, because then to be able to, none of us like to listen to somebody who rants on and on. I realize it's a very self-deprecating statement I'm making right now because I'm ranting on and on. But none of us really like to listen to somebody who goes and on without getting to the idea. The same is true for a contract as well. It has to be brief. It has to say everything it does using the least minimum number of words. So your choice of words have to be extremely nuanced. It has to be selective. and it can't afford to be lazy under any circumstances. You need to be really creative with it. Only when you do all of that does a dead contract, which is boring to read, come alive and start addressing the question that emerge at a later date. So when you draft a contract, and this is why I love drafting a contract. When you draft a contract, you are essentially playing the role of a god, right? It's the closest you come to playing the role of the divine, because you are programming something to come into existence. And that responsibility that you can't take that casually. You have to apply a lot of effort. So like we discussed, in a copyright scenario, we address what is the work that has to come into existence, how much time the person takes to let that work come into existence, what is the quality standards that they have to adhere to when they bring the expression of ideas into force, how many rounds of review I'm entitled to, what is the money that I have to pay, what are the consequences of the breach. All of these I have to address in the contract. Now, while the work comes into existence, all of this will help. But let's assume, for example, that in one of the movies of, say, Anil Kapoor, he has a particular dialogue that he utters, which has no meaning. It's the word jackass. I don't know how many of you have heard it. This is the actual publicity right litigation that took place in the Delhi High Court, and he got an injunction order. So this is a word or an expression from Anil Kapoor in his movies, which he has managed to assert publicity rights over. Now, the dialogue is written by perhaps a different dialogue writer. So he has probably conceived of the dialogue itself, or the word itself that Anil Kapoor utters. Anil Kapoor utters it. Now, who has the right over it? If tomorrow Anil Kapoor becomes a billionaire thanks to that one word going viral, does the script writer get any credits for it, or the dialogue writer get any credit for it, right? And tomorrow if Anil Kapoor goes and says that this is my publicity right, I don't want anybody else impersonating me by saying chakas, then what happens to the guy who actually wrote the word in the first place? So what you need to address in the contract is not just how the idea or the expression comes into existence, but what happens to the expression of the idea after it comes into existence. Who does it remain with? Does it remain with the person who generates the idea or the expression of the idea, or does it come to the person who's commissioning it? So a contract essentially has the challenge of saying that this is the pre-delivery care that a child is getting, but this is the level of the post-delivery care also that the child is going to get. So you need to address both in the contract. Now, in addition to that, what you also then do is you start building layers into what happens to the expression of the idea once it comes into existence. So it can either be licensed or assigned to somebody, or it can be licensed or it can be assigned. I'm sorry. So, and bear in mind that the term licensing and assignment, the distinction is essentially addressed only in terms of the language of the contract. A licensing can be permanent and irreversible. An assignment can be temporary and reversible, right? Both are possible. It all depends on how you are able to craft the agreement. But what the Copyright Act and prudence requires is that the agreement around the copyright has to be in writing and signed. And depending upon which state you're in, you also have to pay adequate stamp duty on it. This is very, very critical. And one of the things that could happen, this is something that we'll have to examine, is there is a new registration bill that is pending before the parliament. If it gets passed, there could even be registration requirements of a whole new category of agreements. Whether it affects these kind of agreements, I'm not sure yet. I'm yet to study the bill in its entirety. But bear in mind that because India has a federal structure where there are rules of the center and rules of the state, you will have to check for these state-specific requirements as well when it comes to our contracting exercise. Between the licensing and the assignment, two things become important, right? What are the spatial parameters, which is the geographical extent, whether the license extends to India, global, Asia Pacific, Oceanic, Europe, Middle East, so on and so forth. Or it could be city specific or even locality specific. It's up to the contracting parties. Then you have to also determine the temporal variables. Is the duration of the license or the assignment 1 year, 2 years, 1 month, 1 week, 1 day, 10 years, perpetuity, so on and so forth. You can also determine whether the license or the assignment is reversible or irreversible. And you also then start looking at degrees of exclusivity. You could have only one person that you give the copyright to and say that you will have such degrees of exclusivity that even I am not in a position to exploit the work anymore. Or you can come back and say that, look, you are exclusive for Bangalore, but another person is exclusive for Bombay. You could come back and say that you are exclusive for me in the locality of Central Business District in Bangalore, but you are exclusive for me in JP Nagar. So the degree of exclusivity is something that you can manage. Exclusivity can be time specific or specific to boundaries. So the limitations and the permutations and combinations for how you monetize copyright is as vast as the imagination around it. You could even divide the copyright rights in terms of sectors. Right, very common with copyright societies. You will notice that one copyright society has the right to go after pubs. Another copyright society may have the right to market and license the music to, say, restaurants. One could get it for, say, a library. The other could get it for, say, any other public setting, like a stadium or a clubhouse. So you could even have that many layers built into it. So you are only limited by your imagination. As long as the parties are able to come up with a creative business model, the contract can be as diverse. And bear in mind one thing, besides statutory protection, the next best category of protection for copyright is the contract. In many ways, it is more crucial than the statutory framework, because a lot of times the statute may say something cannot be done, but a contract can make it happen. A best example with copyright is you could market and license the economic right, which is the right to distribute, right to sell, right to market. But certain rights other than economic, the law is that you can't irrevocably surrender it. Moral rights being a best example. If I write a great book, I don't want it to be slaughtered when it is made into a movie. That's essentially one of the moral rights. The right to be credited as the author is a moral right. Now, by contract, you can't surrender it or transfer it. But by contract, you can agree to give a waiver in terms of whether you should be able to enforce it. So today, if a producer has waiver of a copyright from, say, Chetan Bhagat for a novel that he has written, tomorrow, if, for example, he modifies the book and makes a film, which is one of the accusations against Three Idiots which came out, then chances are that waiver of moral right in the contract can still be enforced, though the statutory protection is not there for the producer. So in many ways, the contract is even more crucial than the law itself. And no amount of care can be sufficient enough. The other thing to bear in mind is that contracts are also not something that are specific to the party's intent. Parties can ideate and intend a whole bunch of things, but sometimes the law may say it is not permissible. The best example is the both of you can arrive at a best agreement possible. But if it is insufficiently stamped, then you can present it in court to enforce it and it's inadmissible as evidence, right? So technically, that means that the witness who will go to the court to resolve the dispute and tell the judge who is right and wrong, he is prohibited from taking the stand because you have not paid adequate stamp duty, right? So that's the final ounce of life that you have to breathe into the contract. So you need to be very mindful that the contract and the law are it's a continuum. They have a cause and effect relationship. So sometimes the contract exists because of the law, but sometimes the law is made possible for enforcement by virtue of a contract, like we discussed in the case of moral rights. So these are the broad parameters to think of when it comes to copyright protection, and it's very important to be able to do this correctly. Any questions so far? Now let's come to a few case studies on how we can how copyright enforcement works. Right. So if any of you have read The Count of Monte Cristo, this will probably be quite familiar. But this is one of the favorite stories of mine when I was growing up, when I first read it as a 10-year-old. So that's why it's an example I love falling back on. The first is the story of Count of Monte Cristo, which is Edmond Dantes, a sailor, has made quite a reputation for himself as an able employee. Envious of his success and his increasing proximity to the owner of the shipping company, he is sent to prison on trumped-up charges of treasonous conduct. He escapes, makes his return as the Count of Monte Cristo, and plots the downfall of his wrongdoers in the book The Count of Monte Cristo by Alexander Dumas. A typical case of a tale of a hero going through the cycle of revenge. Right? He's in the right due to no fault of his own. He's thrust into an impossible position, and then he comes out and essentially prevails over the evildoers. Right, very symptomatic of the hero's journey, which is a crucial plotline in a lot of Western drama. The second story, which all of you will be familiar of in the form of the Game of Thrones series, is that of Eddard Stark, who is an honest servant of the king and discharges his duties as the hand of the sovereign. In the wake of the king's death, he is caught in the crossfire between those who are desperate to succeed him. He too is hauled up on charges of treasonous conduct, like Edmond Dantes, and punished. His family responds and plots their revenge, and this forms the plotline of the famous Game of Thrones series of fantasy novels by George R.R. Martin. Now, if you carefully see the plot between the two, there are similarities. Somebody who is innocent, brought up on charges of treasonous conduct, is wronged, and either himself or somebody on his behalf comes back and takes revenge, right, against the people who wronged him. Now, let's assume that we live in the phenomenal day and age of time travel, and Alexander Dumas actually manages to hitch a ride on the time machine, comes to the 21st century, watches the Game of Thrones series, and is furious. He says, this guy, George R.R. Martin, has copied from me and done this entire tidbit. What he has managed to do in terms of the family taking revenge instead of Eddard Stark is a minor modification. And so is the element of the Night King and the Army of the Dead. You have to now step into the shoes of the judge. Do you think Alexander Dumas has a case of copyright infringement against George R.R. Martin? Any one of you want to take a shot at the answer? For the record, this is the idea versus expression debate, right? One of you brought it up. It's very easy to say that as a line. Ideas versus expression. Ideas not protected, expression protected. But the moment it comes to live examples, these are the challenges. So any of you want to quickly take a chance? Okay, show of hands. First statement. How many of you think that George R.R. Martin is guilty of copyright infringement of Alexander Dumas's work? Use the thumbs up sign to give me a yes. And if you think it's not a copyright infringement, refrain from doing that. So all of you think it is not copyright infringement. Would I be right in that understanding? Okay. Now, Kashish, let me come to you. So you see the two plot lines in front of you?
Yes, sir.
Okay, now the question is, if Alexander Dumas brings a case of copyright infringement against George R.R. Martin, you are the judge, do you think George R.R. Martin is guilty of copyright infringement? Yes or no?
No, sir.
Why not?
So because these two plots are totally different.
Why? Because there is treason in both. There is an innocent man who is convicted of treason in both. And in both the stories, there is a story of revenge against the people who did wrong. So, Kashish, I'm waiting. You have to justify why you think it is not copyright infringement.
Yes, sir. Just give me 1 minute.
Sure. While she's on the topic, bear in mind one thing, right? If you take, for example, the several instances of plagiarism or copyright infringement, nobody, in very few instances, it is a case of, I stand corrected. More often than not, it is a simple case of piracy, right? There is a film that has an official distribution channel. Somebody gets a copy and circulates it on the internet. That's a garden variety copyright infringement case. Very easy to determine, right? But where it becomes difficult is if I feel that the works are similar, and the way a potential plagiarist gets away with it is he makes very minor tweaks, right? So, for example, you have a case of a person who's wrongly convicted comes back and takes revenge. But just to introduce an element of novelty to distinguish it, I suddenly bring in an army of zombies, right? That's the easiest way for me to say no copyright infringement, because I have brought in the army of zombies. In Alexander Dumas's work, there is no army of zombies. If people are able to get away with something as small as a tweak of that nature, then there is no purpose to copyright protection also, correct? So let's really go deep and understand why it is not copyright infringement. And for the record, Kashish, I think you're on to something. Your answer is found in one of the judgments that I'm going to be citing. So be confident, right? Express what's on your mind.
Sir, may I give a try?
Please, go ahead, Sajid.
Sir, it is firstly, I would, as I've typed in the chat box, that's not a copyright infringement because of the following reasons, what I have understood. Because fair use doctrine, because it's a fair use doctrine, there is no substantial copying.
What provisions of the fair use are you invoking?
Sir, fair use, for example, the example which you have stated, it's education. You are stating it for educational purpose.
I'll just pause here briefly for a second. George R.R. Martin became a very rich man thanks to Game of Thrones. So it is not educational purposes.
Sorry. I beg your pardon.
So the movie the series adaptation and the sales of the books made him an extremely rich man, right? So I wouldn't necessarily look at this as fair use. if Game of Thrones, for example, was being kept in the library of your college or being taught in an English drama class, that would perhaps be fair use.
Yeah, I do agree with that. It would be such a case. But if you are saying that he has got a popularity with the what you say series, yeah, and if other persons have signed the contract, they will not copyright or do anything, then they are not. They can be held liable if they haven't signed any contract, and if they copyright the work, and if it is not patented or registered, then I suppose there is no question of copyright infringement.
Okay, so two things to clarify here. First things first, copyright need not be registered for getting protection under the law. Unregistered
Okay.
copyright can be protected and enforced. Okay, so that's a very important point that you brought up, and I want to clarify that. A patent lies in an invention which has industrial application, which is new, which is novel, which is capable of coming into existence, and so on and so forth. So patents will not really be very relevant here. What is relevant is copyright, because it's a literary work, right? Patents operates in a very different field altogether. Okay, so knowing fully well that unregistered copyrights are capable of being enforced, now the question is, has George R.R. Martin copied or conducted or committed copyright infringement by borrowing Alexander Dumas's plotline?
Yes.
He can be held liable.
Yes, he can be held liable for damages.
So whenever you guys get the chance, I want you to go and look up this thing or a theory in English literature called as the hero's journey. Now, hero's journey is a popular theory which essentially says that the story of almost all heroes in Western literature, at least, follows the same trope, right? Somebody who was born into a very ordinary circumstance, who probably did not aspire to be a savior or a hero. Life puts him into a situation where he has to rise above his instinct and do something great. He does that and prevails over far greater or far more overwhelming evil forces. This is the plot line across English literature, from Shakespeare to Charles Dickens to a whole bunch of Greek mythology, right? So if we take the view that Alexander Dumas and George R.R. Martin's books are copyright infringement, the good chance that across Shakespeare, across Edgar Allan Poe, across a whole bunch of authors that we have grown up to like and love, there is copyright infringement amongst one another, right? I know I'm playing the devil's advocate, because when somebody said it is not copyright infringement, I'm trying to argue that it is. And when you're saying it is not, I'm trying to argue that it is actually copyright infringement. But that is also because the law is honestly that difficult to address, right? And this goes to the root of what is called as the ideas versus expression debate. What the ideas versus expression debate essentially stipulates is that the theme of a story, which is a wrongly convicted man who comes back and takes revenge, that is the theme or the central idea, but it is expressed very differently, right? Edmond Dantes is a sailor. He's on a merchant fleet. He lives in the time of Napoleon Bonaparte, where the Republicans and the monarchists are at battle with each other in France, and that is the context for his conviction. In Eddard Stark case in George R.R. Martin's books, it is fantasy. It's an unreal world, right? And there is no France, there is no sailor. He is in fact a governor of a particular region in the north of Westeros. So a very different setting. The characters are expressed differently. The dialogues are different. The kind of setting is different. What weapons they use are very different. So the same theme has been expressed very differently across two different plot lines, though there are some similarities in the theme. So what copyright law says is you can't protect the theme, but you can protect the expression of the theme, right? And that is what you need to keep in mind, because as you go into the case laws, it starts to emerge that holding somebody guilty for copyright infringement when there is original skill, labor, and effort into the so-called infringing work is very difficult. So what copyright law does to address the ideas versus expression debate is adopt a test called as the application of skill, labor, and effort. So if the old work is being asserted against a new work, the question is how much of original skill, labor, and effort has gone into the new work. if there is independent skill, labor, and effort gone into the new work, and it's not just copy and paste of the old one, then chances are that the courts will be very reluctant to give a finding of copyright infringement. That's why you see, as in the remakes, the best example I can think of is Agnipath in Bollywood. There is a version of Agnipath with Amitabh Bachchan and Mithun Chakrabarti that came out in the 80s, if I'm not mistaken. There is a version of Agnipath that came out with Hrithik Roshan and Sanjay Dutt and Priyanka Chopra more recently. The reason why the remakes can happen is because of substantial differences in the way the whole story is expressed. And where those similarities don't exist, you then will have to negotiate for remake rights. Right. So today, in more recently, last year, there was a movie that came out of Bollywood called Kill, which is in a train journey where this commando has to fight through a train full of bandits. Now, this was inspired by a true life story of a Jawan called Vishnu Shrestha. But now Hollywood has secured the remake rights to make the same movie in Hollywood. Right. So when there is absolute similarity of the expression of the idea, remake rights will be negotiated and agreed upon. In the absence of that, you can justify it saying that I have put my own skill, labor, and effort into it and created a new work altogether, right? In which case you don't have to get a license from the original copyright holder. So Star India Private Limited versus Leo Burnett India Private Limited. Please read this because this will be very good for your understanding on the ideas versus expression debate. The court said anything short of mechanical copying. Literally, the court said unless you're photocopying the idea or mechanically reproducing it as it is, it may not be copyright infringement. Right? Sri Venkatesh Films Private Limited versus Vipul Amritlal Shah, they kind of went into a little more detail and said, let's look at the two things. Let's see how much of skill, labor, and effort has gone into it. And then we will determine whether there's copyright infringement or not. Right? So RG Anand and Deluxe Films, again, is another example of how the court said, let's look at the two things. Let's see what is the idea. Let us see the expression. Let's see how different they are. And we will then determine copyright infringement or not. But the two judgments that are very interesting, which try to bring about a science or a rationale for people to determine if there's copyright infringement or not, was Z Telefilms Limited versus Sundial Communications Limited. This is the kernel assessment test. The other thing being the extraction test, which is the Shamal Ahmad Khan versus Falguni Shah. The kernel assessment test essentially arose in the context of a movie which was called Bhagi with Tiger Shroff in the lead. It is supposed to be an action thriller, and there was a certain action sequence which they said was very similar to a prior martial art movie. If I'm not mistaken, it is the Indonesian movie called Raid. Now, one of the things that the court did was it said, okay, let's take a look at the infringing element of the movie, remove it, and we will see how central it is to the remainder of the movie. Can the remainder of the movie still survive if you remove the infringing element? If the remaining part of the movie can still survive in terms of the plot line, in terms of being able to have that impact on the audience, then the court said that, look, it's difficult for us to come back and say that it is copyright infringement. But the moment you remove the so-called infringing element and the entire movie falls apart, there's nothing left for the audience to even watch anymore. Then the court came back and said, sorry, we do not agree. It is copyright infringement. So it really depends on how you look at the two versions of the movie in play and then determine what is similar and what is not, right? And what they did in Shamal Ahmad Khan versus Falguni Shah is they did something called as extraction test. So here they looked at saying that, okay, there are two movies or two ideas or two expressions of ideas which are being alleged to be similar. Let us go to the subsequent expression of the idea, right? Or the subsequent movie. Let us remove all the cosmetic changes or the embellishments which have no essential bearing on the theme, plot, and storyline. And then let us compare whether the two things really make a difference or not to determine similarity or dissimilarity. If after you remove the embellishments, it appears almost identical, then the court comes back and says, yes, the subsequent work is a plagiarism or the previous one or the copyright infringement of the previous work. But after you remove the embellishments, what survives still appears to be very different. Then the court says no copyright infringement. So Kashish, going back to the Game of Thrones example, the question, and I don't have an answer, is whether the two tweaks of the family taking revenge instead of the main character who is wrongly convicted, and two, the army of the dead or the army of the zombies, whether they're mere embellishments or whether they introduce a crucial plot twist. will determine whether Alexander Dumas's copyright claim succeeds or not. Once you see Game of Thrones, you realize that the Night King and the Army of the Dead is not just an embellishment. It represents how, when humans are bickering amongst each other and trying to engage in a Game of Thrones, larger threats can come and threaten all of humanity. So if you have to apply a real world parallel, countries going to war with one another, but climate change happening simultaneously, right? So climate change is essentially a parallel for the Army of the Dead. Now, when you look at it that way, the Army of the Dead is not just an embellishment. It is a lot more crucial. It's in fact a very crucial distinguishing feature of Game of Thrones from the Count of Monte Cristo. But the moment it is there, then the whole thing changes. But if the Army of the Dead serves no purpose and they're just hanging around in the background, right, without there being any other impact around it, then the court will come back and say, sorry, George R. R. Martin, you're guilty of copyright infringement. Any questions so far? Bear in mind, this is not an exact science. It is evolving, right? So very subjective. Okay. So we quickly come to the last slide because I realize that I'm really overshooting time. So there are two principal forms of remedies available to you when you feel that there is copyright infringement. One is civil, the other is criminal. Criminal, I think I will touch upon because it's a lot easier. That's when the police can get involved. They can go and seize infringing copies, arrest the person. A state public prosecutor gets involved and tries to bring a conviction where there is imprisonment and fine. Now, criminal is best resorted to when the nature of the copyright infringement is in the nature of piracy, where you don't have to go into questions of similarity, whether the latter is a infringement of the former or not. So if I was dealing with the case of Alexander Dumas and George R. R. Martin, I wouldn't invoke criminal remedies, though it is in theory an option, because for a policeman to make the determination of whether George R. R. Martin's work is similar or not, they don't have the bandwidth, even if they have the competence. But if George R. R. Martin's series is being put onto CDs and sold in Burma Bazaar in Bangalore, then I would go to the police. And the best way to approach the police is to first to get to know them. A lot of times, the best approach is to go to the inspector of the local police station and start there. Other times, you may want to go to the commissioner of police and then tell him to give the inspector instructions to conduct a raid. Because a lot of times, when you file the complaint early enough, there is a good chance that due to some leaks in the police department, the infringer gets to know and shuts his shop and removes the infringing product. So you have to get to know the police in the jurisdiction where the enforcement has to take place, hire local expertise who can give you guidance on how the police function, then craft your criminal strategy. With civil, you can get either legal or equitable relief. Legal is damages, equitable it could be prohibitory injunction, where you get the person to stop infringing the copyright. It could be an ant-on-pillar order where you essentially have an order to search the premises of the defendant and seize the infringing copies. It could be a mare eva injunction requesting them to not dispose of the infringing copies and keep it alive, and to keep some assets alive so that if you recover money tomorrow, you can enforce it. And for all of this, what is critical is the role of the court commissioner, whose powers are specified in Order 26 of the Code of Civil Procedure. So you get a court commissioner appointed who is usually an advocate. Advocate is then given a mandate by the court that you are allowed to go search and seize the infringing copies in the premises of the defendant. This is a double-edged sword, because a lot of times when you go and conduct the raid and you find nothing, your entire case could die. So you need to have reliable investigators who give you intelligence. And these are usually private investigators that you can engage. They come at a price, but they're very valuable, right? And then you get a court commissioner appointed, you file something called as a memo of instructions, where you tell the court what all the court commissioner has to do to implement the search and seizure operation and the freezing of assets. And then the court commissioner you can even make an application directing the police to render assistance to the court commissioner. So then the police will come with the court commissioner, a raid will be conducted, court commissioner will seize all the infringing copies, make a report, collect the statement of the defendant and file it in court. And then you go into the court proceedings, right? So very valuable tool. A lot of big companies, including Microsoft, Siebel Systems, they employ this strategy extensively, where they send an investigator, collect intelligence. Based on the intelligence, they go to court, and then they essentially end up conducting a raid, seizing the infringing copies. You can apply for damages, but bear in mind, a lot of times the infringer may not have money to pay damages, in which case you have to look at attaching his assets, getting the assets auctioned. But in the context of trademark infringement, we had a record award of, I think, $38 million by the Delhi High Court for Amazon in a recent infringement suit involving the sale of some infringing products. So Indian courts are also now not hesitating to award huge damages, but you still have to prove actual losses, right? Which is not an easy task. That brings me to the end of the conversation. Thank you very much for your patient hearing and for your participation. I recognize that I was being very irritating by continuously prodding all of you, but I hope you found it helpful, and I hope that we start looking at imagination as a national imperative and not just as something that we do as an extracurricular activity in the aftermath of this conversation. Thank you so much.
Yeah, thank you, Ashok. And I think that's a very, very strong message at the end of this whole session. That imagination is not something that you do as an extracurricular activity. It is of national importance today. Absolutely, and fantastic. I did make a few points, just to sum up of what we have learned today through the sessions. And practitioners, please take this, that whatever has been discussed in the session today is very, very critical. Right from understanding the categories of copyrights to understanding the concepts of what is commissioned work. You might come across documents which says a sort of commissioned work kind of an agreement, or something which says work made for hire. So these are some things that you will have to be really, really watchful about what they mean and what they are in the context of copyrights. And Ashok also very rightly brought about the concepts of licensing and assignment. And we always had that thing, that it's very compartmentalized. If you say licensing, then it's not perpetual. Assignment is perpetual and various other things. But the language of the contract makes the whole agreement, makes it all. And the different dimension, one very different dimension to contract. As we always thought, contract is something like a piece of paper exchanged or something of the sort. But he brought a very, very important aspect to it, where he says it is a scribe that stands as a witness to the parties of whatever they have agreed upon. So that's a very important takeaway again for us. And of course, a lot was discussed regarding the contract and how we program the contractual relation through, and through these formats and other things. And the case studies brought about a lot more interesting aspects of the idea versus expression dichotomy, and I think that brought a lot more clarity in the subject. Please do go through those cases that had been shared with you on the screen, and I think we would have these recordings, so you can just go over and note down those cases. Those cases are very, very important. They're very critical. So these are all some important takeaways of today's sessions. Any questions, please feel free. We don't have too much time. We have overshot, but maybe one or two questions right now, and otherwise you could write to us and we can give you the clarifications. Any questions?
Madam, one question from my side.
Yeah.
Can you the details of Gayatri Madam who had taken the session last Saturday, if possible?
We will talk about that later, offline. We'll just discuss what is very specific to this session.
Okay.
You could write to us, but in this specific session, and if you have any questions here, then we can take the discussion.
Great design.
Looks like, anybody? Okay. So, probably one message, one question, whatever. No, ma'am. All right. Okay, Kashish, thank you. So, Ashok, thank you so much. And thanks for being with us on this Saturday evening. Thanks for your time. And should our participants have any further questions, maybe we will just, pose those questions to you for clarifications and other things in the times to come. So thank you very much, and have a great weekend, all of you. Thank you.
Thank you, madam.
And I look forward to meet you all. Just one quick announcement before we all leave. So 18th of June is going to be the next trimester of our 6-month program. And in the meantime, I would also request our participants to please go through the videos and start doing up your assignments, because they are all graded. Your assignments, the MCQ assignments are being graded. So please go through the reading material, and whatever is being discussed through these live sessions, that's the whole idea. It sort of sums up whatever our video lectures are, and it's also a sort of of, it really supplements your learning with experts like Ashok, Gayatri, and Lex Orbis, who had joined us earlier. So please go through all of these, and I'll see you in the next
Just one
next
point.
couple.
Some of the articles that I referred to, I put it on the chat group.
Oh, great, great. Yes. Has this been put up?
Yes, ma'am. So I've posted, I think, 4 articles on the.
Oh, yeah. I think you posted a private message. If
Oh, shucks. Sorry.
yeah.
Let me just quickly send that to.
Yeah, I think it's important that we make a note of these. These are very important links. Before we close, before we leave this meeting today, let's just take a note of these links and please go through them.
Okay, so I think just for some additional.
Yeah, we'll make a note of this. I'm just saving them also, just so that. So thank you, Ashok, and thank you everyone. I'll see you in the next couple of weeks. Thank you. Bye.